Okay, sorry for that interruption. It was a very important client call. Anyhow, let's proceed to Article 126, the delaying release. So as I have mentioned earlier, no, that I have a personal experience here. My client was detained because she was accused of committing an adultery, and then the police officer, since this is a light offense, according to the law, no, the police officer should deliver her, no, the person accused, to the proper judicial authority within 12 hours, since this is a light offense. So if my client was brought into custody at, let's say, 6 o'clock in the evening, 12 hours is 6 o'clock in the morning, but the prosecutor's office is still closed. So even if the police officer wants to deliver her to the prosecutor's office or to the proper judicial authority, he cannot do so because the office is still closed. But the police officer should have brought my clients directly at 8 o'clock in the morning. But what happened then was my client was brought to the prosecutor's office at around 3 o'clock in the afternoon. So there was a delay in the delivery. We are supposed to file a case against that police officer, but we did not push through because we should choose our battles. Not everything that is not everything should be subject to litigation. We should choose our battles. We focus more on our primary case, which is the case of adultery, which luckily we won. Okay. Anyhow, delay in delivery of detained person is not the physical delivery to the fiscal's office, but it is really the filing of the complaint. Okay. Again, criminal procedure, no, after a person is being arrested, no, for warrantless arrest, okay, for warrantless arrest, this person should be brought to the office of the provincial or city prosecutor for him or her to be subject to a PI, preliminary investigation. Okay. Inquest proceeding. I'm so sorry. The inquest proceeding. If warrantless arrest, the person being detained should be brought to the fiscal's office for an inquest. Then, according to the law, no, within the specific period of time, depending on the gravity of the offense, the person should be should be charged before the proper courts of the law within the prescribed period. So after the inquest, the fiscal will have his or her resolution, no, determining if the arrest is valid. If the fiscal determines that the arrest is valid, then he or she shall prepare an resolution, no, an inquest resolution recommending the charge, the filing of appropriate charges, no. So that is criminal procedure. Okay. So you need to understand here in the detained person that the police officer who detained, no, because again the first element is that the offender is a public officer or employee whose official function include the detaining and arresting of a person. Okay. And then that the person is detained for legal grounds. Here, kahit legal yung pagdakip nyo or kahit legal yung pag-detain ninyo, no, dapat pa rin i-observe yung 12, 18, 36 hours na filing of charges. Filing of charges, hindi inquest. Filing of charges. Okay? Sorry. Filing of charges. So, under this rule, no, or under this law article, we need to understand 12 hours for light offenses, 18 hours for crimes punishable with correctional penalties or their equivalent, and then 36 hours for offenses punishable by capital punishment or afflictive penalties. Okay, so you just need to remember 12 light penalties, 18 correctional penalties, crimes punishable with correctional penalties, and 36 hours crimes punishable by afflictive penalties and capital or capital punishments. Okay? So yun lang, delay in delivery of detained person. Very simple, okay? Very simple lang. Basta ang reckoning time 12 hours for light offenses dapat na charge na before the proper courts of the law. Okay? Yun ang ating dapat pagkatandaan. Okay? Then, delaying release, okay, this is the opposite naman, no? Na-detain na yung person, okay? And then, there is a detained or na-imprison na yung person, and then there is an order na from the court, no? Or proper judicial authority, parang ordering the release of the person, okay? Release of the person from the jail facility. Hindi mo sinerve, no? The police officer or the bureau, BGMP na naman ang may kasalanan nito, or the police officer might be also involved. Hindi nila na-serve, hindi nila pinarases properly yung discharge papers ng detained person, then they may be held liable for this. I heard a news, no? Parang there is a person, an inmate, parang dapat na-release na siya but after 2 years pa, no? Parang nagstay pa siya sa prison facility for 2 years because of this. Na-delay nila pag-process yung release paper niya. Those people involved who are negligent in their duty should be held guilty under Article 126, delay or release. Hindi ko na masyadong i-discuss yan kasi hindi yan masyado favorite for the board exam. Yun lang, arbitrary detention vis-a-vis illegal detention, and then the delay in the delivery of detained person. Yun lang ang mga important. Then expulsion, there is a case I want you to remember. A case involving the city mayor of Manila, no, long time ago. Parang pumasa sila ng ordinance or ng executive order. Lahat ng mga prostitute sa Manila, no, pinauwi niya sa Davao City or pina-transfer niya sa Davao City. Pino-force niya na umalis sila sa City of Manila because of moral grounds, no. Hindi siya that act is clearly illegal, no. The mayor has no right, no, to expel someone arbitrarily, no, illegally from a certain place. Dapat may reason for that expulsion, no. And then under this case, no, sabi ng Supreme Court na bawal yun. That is a violation of the right of abode, no. Abode, ibig sabihin sa Binisaya pa pagpuyo, no. In Tagalog, I don't know what is the correct translation into Tagalog, but right to abode is the right to choose where to live, okay? Kung saan ka gusto tumira, then you have the right kung paano mo yun i-exercise. That is the right to abode, the right to choose where to live, okay? So, you cannot violate that. If you will violate that, then you will be held liable under Article 127. So, elements, offender is a public officer or employee. Hindi na specify kung ano yung official function niya, and that he expels any person from the Philippines or compels a person to change his residence, and that the offender is not authorized to do so by law. Okay, so sir, when do we authorize the change of residence? Like for example, na-convict ka, ilagay ka na sa Muntinlupa, then there's a change of your residence. You cannot say, no, I am from Camiguin, I don't, my right to abode is being violated by that order na ilipat ako sa Muntinlupa Jail? No, because there is a judicial order already convicting you of a crime and ordering you to be detained or to be in prison in the Muntinlupa Jail. So that is a change of residence, no? So you are now a resident of Muntinlupa. Okay? So that is part 2 of module 4.